they shall not be punished for crimes they committed. Only the leaders of the Democratic Cambodia group shall be prosecuted, and though he's merely the chief of a prison, similar to those chiefs of the 195 prisons throughout Cambodia, that they were considered by the trial chamber as perpetrators and they failed outside the jurisdiction of the ECCC. And why only Dutch out of those 195 prison chiefs failed within the jurisdiction? And I would like Your Honor to pay attention to this point. Article 9 of the law on the outlawing of the Khmer Rouge clearly states to that effect, any person who violates the law and violates the right of the people by wrongly accused or wrongly making arrest or detention of people will be punished from 2 to 5 years imprisonment. I don't want to again and again repeat all those articles. And for Article 2, from the date the law comes into effect, any person who is a member of a political party or a military force of the Democratic Cambodia shall be considered offenders against the Constitution and the law of the Cambodian law. And Dutch came into Cambodia 2 years and 6 months before the law comes into effect. And if Dutch resisted and still continued committing offenses, then Dutch would violate the law. However, from the date of the law coming into effect, Dutch did not commit any offense against the constitution or the law of the Kingdom of Cambodia. Therefore, Dutch, the chief of S21, he should fall outside the jurisdiction of the ECCC as those of the 195 chiefs of other prisons, and that is the main point on the jurisdiction for Your Honor's review. And on another point, the appeal by the co-premiers of Cambodia dated the 27th of July 1999 that all civilians or military officers living under the supervision of the Khmer Rouge to find all means to return to integrate with the government. And at that time the government publicly made an announcement, and they will not be punished. Instead, their status and rank will be preserved. And even now at the Ministry of Defense, there are still former Khmer Rouge cadres who have their rank and status. Dutch entered more than 2 years before such an appeal, and now he is punished. He shall only be punished for his resistance to integrate in the society and continued committing offenses. And Article 7 of the Code of Criminal Procedure 2007 states that the extinction of the criminal action, and the reason for such extinction is that the government made an appeal, and also the government issued such a law in 1999, and also the Paris Peace Accord dated 23rd October 1991 which prohibits the constitution and the law to punish for those who commit the crimes in the past. For the aforementioned reasons, Dutch saw fault outside the jurisdiction of the ECCC, and I urge Your Honor to review this matter seriously. The trial chamber agreed with the charges by the co-prosecutors, who are themselves unclear on the issue whether the accused shall fall under the category of those most responsible, which clearly stated within the jurisdiction of the ECCC, and it states that even Dutch is not the senior leader of the Democratic Cambodia, he shall be considered falling in the category of those most responsible for the crimes. The concurrence on this unclear stance is a serious error made by the trial chamber, and it contradicts the Rule 87.1 of the internal rule of the ECCC, and it contradicts Article 38 of the Constitution of the Kingdom of Cambodia, which states that any doubt shall benefit the accused, and the wording that he shall be considered amongst the most responsible, it means it's like a 50% chance. It's just a possibility, so there is a doubt, and in this case, if doubt exists, the benefit shall be for the accused. And the group of experts were also hesitant more than those stipulated in Article 1, that is on the determination of those who were most responsible for crimes and grave breaches of national and international laws. It states that if it were to be true, and that is the wording used by the group of experts, if it were to be true, for such a language, it means there is a doubt, and the accused shall be acquitted and not found guilty. Based on the ECCC law, which is a combination of the administrative and criminal standards for the selection to prosecute those senior leaders and most responsible for the crimes committed during the Democratic Cambodia regime, it requires the chamber to consider seriously on a matter of personal jurisdiction based on the administrative law of the Kingdom of Cambodia in order to identify those people. In the case of Dutch, there are national documents clearly identifying the role and the status. That is, he is not part of the senior leadership structure or the most responsible for the crimes committed during the Democratic Cambodia regime. For that reason, there is no doubt that the accused shall fall outside the jurisdiction of the ECCC. As chief of S21, which is one of the almost 200 prisons throughout Cambodia during the Democratic Cambodia, S21 has a less number of casualties who died, and in Chong Chroy, for example, in Kapong Chnang, 150,000 prisoners were killed, and in other prisons, more prisoners died. The point is that the ECCC law does not determine those people who were chiefs of prisons falling under the category of those who were most responsible. They were considered falling outside the jurisdiction of the ECCC. This is another point that Your Honor should consider regarding the personal jurisdiction of this court. The 195 prisons fall outside the jurisdiction of the ECCC, and S21, which is also another prison, it should automatically fall outside the jurisdiction as well. Or is it because S21 killed less people, that's why it falls under the jurisdiction of the ECC? Maybe if there were more than 100,000 or 200,000 people died there, then they would fall outside the jurisdiction? In paragraph 119 of the trial chamber judgment states that amongst those security centers, S21 is the only one with specific characteristic, as it has a direct connection with the center and which had the right to detain the cadres of the Communist Party of Cambodia. So it clearly states that S21 is so special, it's so specific, that's why Dutch has been prosecuted. And the specificity is that it had a direct connection with the center. And that is the only point that the trial chamber relied to prosecute Dutch. And the other chiefs of prisons did not have direct connection with the center, and for that reason they were not prosecuted. And I would urge Your Honor to review that as well. Sopam, who was the third person in the standing committee of the Communist Party, it did not have a direct connection with the center, or is it? And Chit Chun, alias Mok, also controlled a zone, and he was the fourth person in the center. Why these two fell outside the jurisdiction of the ECCC? Don't you think it has a direct connection with the center? And why only S21, controlled by Son Sen, who was the seventh member of the standing committee? And another point is that S21 had the role to detain the Khmer Rouge cadres. And if we were to prosecute the chief of S21, it means we try to find a justice for those Khmer Rouge cadres. A handful of people or innocent people were killed, but the majority of those who were killed, based on my estimation, they had the blood on their hand. For example, Koi Thun, Won Wait, before they were brought to S21, they made a decision to kill several people outside. Your Honor, I am of the view that this is one of the factors which require the bench to provide further consideration. And in paragraph 677 of the trial chamber judgment, it finds that Kang Gek Il, alias Dutch, guilty for crimes against humanity. And what is that? Because it states that Dutch enslaved those who were killed, who were sentenced to them. And what happened to the other 195 prisons where those detainees became millionaires? And why the chamber doesn't find justice for them? And it accused that Dutch detained those people at his center So it means at the 195 centers, those people were detained outside or were they kept in a hotel or something? And also in the same judgment, it states that Dutch was accused of the grave violation of the Geneva Convention of 1949 for willful killing. Let me ask your honor that what happened to the other 195 prisons? It means were they unwillful killings existed in those centers or prisons? And it states that at S21, Dutch tortured the prisoners. Does it mean that torture was not committed at the other prisons? And for inhuman treatment at S21, it means those inhuman treatments were not committed at the 195 prisons? And why the EECC doesn't try to find justice for the other 195 prisons? It also states that S21 illegally detains the civilians. What happened in the other 195 prisons? Were those detainees detained legally? Please consider this. Also in the judgment, 12,373 people were killed at S21. That's why Dutch was prosecuted. What about the killings of those thousands, hundred thousands at other prisons? Why those chiefs of the prisons were not prosecuted? It means in this judgment, the prison chiefs of other prisons were considered perpetrators and they were not prosecuted. Once again, they were considered perpetrators. And only Dutch at S21 and his chief of S21, he also saw be considered perpetrator. The judgment said Dutch is not a perpetrator in the categories for those 195 prisons. Do you think that is fair? Of course not. The co-prosecutors state in their response that there is no law to charge those other 195 prison chiefs as perpetrators. And if there is the case, how come Dutch was charged for the same status? So, Dutch was also a perpetrator as those of the 195 prison chiefs, and he saw fall outside the jurisdiction of the EECC. These are the conditions of personal jurisdiction that I would urge your honor to review. In the indictment, in the amended indictment, it states that as the Deputy Secretary of the S21, he led the interrogation team and joined in the establishment of S21 and gave instruction to the interrogation team how to interrogate. So as Deputy Chief of S21, he had an overall supervision of S21, including making annotations on the confessions and the order to kill. S21 is the most important prison for Democratic Cambodia and considered as part of the infrastructure of the Communist Party of Cambodia, as it reported directly to the highest echelon of the regime, and it operated throughout the country, and it received senior cadres and other people throughout the country. The trial chamber agreed to that allegation in the indictment without relying on any legal basis. In order to make the accused fall within the category of the most responsible person, as it considered S21 was an important center, and there is no legal basis for such assertion in identifying those who were most responsible. Does the law have to adjudicate the prison management throughout the country, or does it only adjudicate the person or persons who were most responsible? In theory, the law on identifying those who were most responsible relied on the discretion of the person based on his authority within the status determined in the administrative structure and law. And as the secretary of S21, Dutch had the role to only receive the prisoners who were sent throughout the country, then they would be interrogated and they would be sent to be smashed based on the orders from the upper echelon. This does not mean he is the one who had the most responsibility, as the acts did not derive from his own discretion, and his acts were identical to those acts performed by chiefs of other prisons throughout the country. Another mistake is that S21 was considered that it was formed with the participation of the accused. That is incorrect. Based on his minor role as Deputy Secretary of S21 and within the political framework that he is not a member of the Standing Committee, the accused had no ability to provide opinion through the party on all issues in relation to the security policy and measure. Such allegation is preposterous. In fact, lawyers acknowledge that the prison section is an apparatus of the state, and all establishments or dissolutions or modifications are within the decision of the state. No single person or two persons can form such an establishment. S21 was established according to the decision of the Standing Committee during their meeting in October 75, giving the authority to Son Sen, who is a member of the Standing Committee, to be in charge on the security. Throughout the world, the prison, the police or the military police, they are the tools of the state. They are under the commands of the state, and the state shall be the legal entity to be responsible. And that means Pol Pot, Son Sen, etc. They were the one who issued order. And now when mistakes were made and only the tool were to blame, and Dutch was just a tool used by those people, and he shall fall outside the jurisdiction of the ECCC for that reason. In paragraph 2 of in paragraph 2 of 33 of the indictment, Dutch as Secretary of the S21, he had no de facto authority for the overall supervision. He only had the authority to disseminate information from the upper echelon. That here, if we have to look at the structure of the party, there would be the secretary, that is Pol Pot, and then the zone secretary or the division secretary, and number 3, the sector secretary, and then the regiment, etc. And number 4, the secretary of the district committees, or the office committee, as in the case of Dutch. So Dutch would fall in the 4 category, which is the lowest rank within the party hierarchy. Dutch was just a minor secretary who had no real authority to make decisions or to do anything contradictory to the directions from or the orders from the upper echelon. Therefore, he could not be considered the most responsible person. According to the opinion of Judge Cartwright, who states that the Communist Party of Cambodia was the one who identified the enemies and who ordered the arrest of those enemies. And she states that the accused was not aware of the secret decision dated 30 March 76. Therefore, he could not be said he participated in the planning of such policy. This clearly states that Dutch was not the one who was most responsible for the crimes mentioned above. This is another condition to be considered in regard to jurisdiction, and I would urge Your Honor to review that as well.
There are other evidence that proves that Dutch had no power to make any decision for any arrest or detention of prisoners. For example, in the case of Koi Thun, Won Wade, and Nat, they were arrested upon orders from superior, including Son Sen. And Phang Ton, Rut Kut, and other people, including Dutch in-law, were also arrested, and that he had no power to intervene. For this reason, it is true that Dutch was not most responsible for the crimes and grave breaches or violations of domestic and international laws. And these are part of the jurisdictional condition that need to be well reviewed by the chamber. The President interrupts. Counsel, please be informed that it is now time for morning adjournment, and you still have 50 minutes left. I think you may take the opportunity after the break to proceed with the remaining of your oral submission. We will now take the morning adjournment.